I have two ways that I can handle this. All right. I am not handling it in a way that is the most harsh. I told counsel that I would give you that admonishment. All right. There's a circumstance where you're legitimately there. Talk to your attorney about that. Okay. And they will be able to advise you what you should do in those circumstances. I am giving you my warning, right? Am I understood, sir?
I heard exactly what you said. So you told me to ask my counsel if I have any questions in regards to being justified at any location.
Sounds to me like it may have been that you were there. She may have showed up in the area or whatever. I'm not attributing any ill will to that. I'm just going to inform you that you happen to be up. You're required to leave, okay? Be in that area. Am I understood?
How does that work?
Just say yes. Any potential conflict between this honorable court and the office of the public defender. While the people do not believe that any such conflict exists, we make this waiver in the avoidance of all doubt.
Thank you, sir.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender. Your Honor, we too do not believe that there is a conflict, but if there is such a conflict, we'll waive it.
All right, thank you. Court for its part also does not believe there's a conflict either under Michigan court rules or the case cited thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people versus Deshaun Gainey.
Morning, Your Honor. Special Office of People.
Morning.
Morning. Brian Bowling on behalf of Mr. Gaines, should be zooming in from MDOC facility.
I think he's there. Mr. Gainey, can you state your name, please?
Deshaun Elijah Gang.
Thank you. I have before me a plea form that indicates he's going to be pleading to an added count 3 of false pretenses, 200 to 1,000 to 1 year offense. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. Defendant is also agreeing to pay restitution in the amount of $820 to Collier.
Yes.
And $506.95 to Meyer.
That is correct, Your Honor.
That's my full understanding as well, Your Honor. I did discuss that plea resolution with Mr. Gainey over the phone on Tuesday. He wants to accept it. He did give the authority to sign the plea form on his behalf and the advisor rights form, which we did review.
All right, very good. Gainey, can you raise your right hand, please, sir? Solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God.
Yes, sir.
All right. State your name again for me, please.
Deshaun Elijah Gang.
All right, Mr. Gainey, it's this court's understanding you're going to plead guilty to the charge of false pretenses, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, sir.
Understanding that, you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You had your attorney execute an advice of rights for you. Is that correct, sir?
Yes.
Any questions regarding any of those rights?
No, sir.
You understand that you're waiving or giving up all of the rights that are contained on that form.
I understand.
You understand you're giving up your right to appeal love right.
Yes, sir.
Are you on probation or you're not on probation or parole? That's a silly question, but I got to ask, right?
Well, I'll be on parole upon release, but not at the moment, no.
Say that again.
I said I'll be on parole upon release from prison, but not at the moment, no.
Not it. All right. Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, I am.
and also of your own free will because you believe that you're guilty of this offense?
Yes.
All right. On the date of August 21st, 2024, at the location of 2723 Oak Valley Drive, Pittsfield Township, Washtenaw County, State of Michigan, what'd you do that makes you think that you're guilty?
I obtained credit cards.
Okay, you obtained credit cards, but you didn't have the authority to use those credit cards?
No, sir.
All right. And guessing from the restitution, you went into Meyer and used those credit cards?
Yes, sir.
And then you received some type of goods or products from Myers by using those credit cards. Is that correct?
Yes, sir.
All right. So I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, that if you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, sir.
Is counsel aware of any other promises, threats, or other inducements which have led to this?
No, Your Honor.
I'm aware of none.
Have I complied with the court?
People are, that's fine.
We have, Judge. Thank you.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be, she's gonna be able to get to him by then. May 27, 2026, 12 noon.
What day?
For me. Pardon?
What day is sentencing?
May 27th.
Okay.
Okay, my probation officer will be in touch with you. Okay? All right, thank you. Bond continued.
Thank you.
Court calls case in People versus Winona Harvey.
Ashley Feltus for the people.
Your Honor, Joy Gaines, Senior Assistant. Representative Harvey? Harvey, would you
Yeah.
state your name?
Yes,
Would you state your name, please?
Winona Harvey.
Go ahead, Ms. Gantz.
I've received the report and at this time would stipulate to the report.
Where she is still incompetent, same, but restorable.
That is correct, Your Honor.
Do I have any other additional information?
No, Your Honor, we also stipulate to that report submission and ask you if I make that finding.
All right. Court will make the finding that the defendant is incompetent but restorable. I'll set a review date for August 6, 2026, 9 a.m. Bond will continue.
Thank you.
Well, we'll continue, Judge. Wait a
Say
second.
again?
What's gonna continue? What's
Is it
going on?
continue?
What's going on?
What's going on?
Yeah.
Okay, I made a finding based upon a report we have that they're trying to restore you to competency. So as soon as I get that order, I'll sign it. And then we'll see you in August.
Okay.
Okay? Thank you.
All right.
Can you make sure that somebody prepare an order for the court on that finding? Court does call the case, People versus Anthony Reeves.
Morning, Your Honor, Raymond Cook for the people.
Good morning, I'm Rob Chico on behalf of Mr. Reeves. Anthony, would you state your name for the record?
Anthony Lamar Reeves.
Thank you, sir.
Judge, I had a phone conversation with him this morning. My visit kind of got screwed up, but that being, as he set this for exam.
Your discovery is complete.
Sure.
And what facility are you in, sir?
In Lapeer to some.
He's in Lapeer. Because we're on the 19th now. I'd have to set it either for the 26th or June 2nd.
Judge, he'd like the earliest possible date.
Really as possible. Okay. I'll have to go a little further out so we can get it transported down. People have their witnesses available on the 26th.
Do our best, Your Honor.
Preliminary examination in person will be set May 26, 2026, 9 a.m. before me.
Anthony, I'll come out and see you, okay?
Bond. Thank you, sir. Court calls the case, People versus Toronto Rogers.
Morning, Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Assistant Public Defender Chelsea Vergils with and on behalf of Toreno Rogers. Mr. Rogers, please state your name.
Torino Smalley Rogers.
Thank you, sir.
Your Honor, I'm asking to adjourn this probable cause conference. There's an update on the plea discussion I need to share with my client and has unfortunately not approved me as a visitor.
They've not.
No, I applied though.
Okay. Probable cause conference, May 28th, 2026, 9 a.m. I'll continue.
Thank you, Your Honor.
Thank you. Court calls case, People versus Rajad. Is it Ashta Parsik?
Morning, Your Honor. Raymond Cook for the people.
I'm sure that's correct, Judge.
That's all I could.
Ready, Judge Torshio Feaster, Assistant Public Defender on behalf of my client, who should be on Zoom. Please state your name for the record, sir.
Riyadh Azdarpazik.
Exactly what I said.
Yes, sir.
He did good. He did great. Yeah.
Thank you. Thank you for the compliment. I blew it. I know it. All right. What are we doing?
To my knowledge, all discovery is complete. We're asking for an exam date, please, Judge.
People have their witnesses available the 19th.
Do our best, Your Honor.
Preliminary examination in person will be set May 19th, 2026, 9 a.m. before Judge Garwood. Bond will continue. Thank you. That's an in-person hearing, sir.
Thank you. Thank you, Your Honor.
Court calls the case of the People versus Dion Baldwin.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. Joy. Thank you. Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Baldwin.
Your name, sir?
Dion Tar Baldwin.
All right.
This matter was adjourned last time for some additional time from us, for our office and Mr. Baldwin to go over the, and to consider the recommendations in the evaluation, which we're recommending that Mr. Baldwin be found not competent but restorable.
What's the date of your report?
Your Honor, we were in court 2 weeks ago, so that I will grab my laptop. So it said
Right, and then we had to adjourn it out, but I got it. From a February date?
that is correct.
Okay. Yes, and I reviewed that. So you're stipulating to that report?
That is correct, Your Honor.
People stipulating?
Yes, Your Honor.
Based upon a review of that report, the court would find the defendant at this time is incompetent to stand trial but restorable. And I've signed an order to that effect. I will set a review hearing in this matter for August 6, 2026, 9 a.m. Bond will continue. Thank you.
One second, I'm just gonna wait for them to fulfill.
Court calls the case, People versus Derek Hunt. Sorry, AG.
Good morning, Your Honor. Sarah Runner, Assistant Attorney General for the people.
Morning.
Assistant Public Defender Chelsea Vergils with and on behalf of Derek Hunt, who appears via Zoom. Mr. Hunt, state your name.
Derek Hunt.
All right. Where?
A month if possible. He has made a payment and he's ready to make further payments. My understanding is there's a change in the total amount owed. So I think we're close to, moving on in this case, just asking for a little more time.
All right. Any objection from the people?
I'm not sure, why do we keep delaying it here instead of just waiving up and entering the delay plea then? I think he's in a position where we can move forward with that if you'd like.
Okay. I did not realize that. I apologize. Is it possible to ask Mr. Hunt on the record if he'd like to waive?
Well, you haven't had the conversation with him, right?
I have discussed, Mr. Hunt, do you remember me telling you about your right to a preliminary exam and how any offer in this case requires a waiver of that exam?
Yeah, I briefly, that's our first conversation, yeah.
If you'd like, you can waive today, move up to circuit court, and we can seek a resolution there based on the offer I previously discussed with you.
I would like if we can still just like try to adjourn it for at least one more month. I have majority of the money, so I'm just making sure I have all the funds.
Okay, that's fine if he needs one more adjournment. I'm looking at a balance of just over 31,000 right now. Just so we're aware, but yeah, that's fine, Judge, if they
Just
need more
over
time.
31. All right.
Yeah.
Probable cause conference will be adjourned June 4th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you. And Madam Attorney General, you see that figure that you gave, did a $5,000 payment get attributed to the account? Can you see that?
I see an over $10,000 payment that was attributed to the.
Okay. So that must include this because it closed out over there. So it probably got over and applied. I just wanted to make sure it got applied, his bond.
I don't think that the bond amount is included. I think that was two separate payments. If I'm understanding based on a previous discussion, the bond amount hasn't been yet applied to what you're saying has been paid.
I
So
see a payment. Yeah, I don't see a recent bond payment. I don't see a recent payment of $5,000. No.
It would have been February.
it would have been in February.
No, I do not see that. So that's still somewhere.
Oh, great.
And
Okay. We'll move on and I'll see him in a month and we'll check on that to make sure that 15 sent over that to the court.
Thank you, Judge.
Thanks, Your Honor.
Thank you. Court calls the case, People versus Timothy Cunningham.
Good morning, Your Honor. Good morning to your staff. May it please the court, move to vehicle P86437 on behalf of Mr. Cottingham, who's approaching to my right. Sir, could you state your name for the record?
Timothy Cottingham.
Thank you.
Date and time set for a probable cause conference, Your Honor. We are asking that this matter be set for preliminary exam. I am requesting.
All discovery is complete.
Yes, Your Honor. I am requesting a date of June 2nd. We do have trials on the 18th, pushing into 19th
You
as well as.
don't get to request your date. What's the reason?
We have trials on, I believe it's going to push into the 19th, and then we have a federal trial starting.
Whom?
Myself, Attorney Martell, and Attorney Nasser.
And Your Honor,
Yes.
we received about 200 pages of medical records from the victim in this case. I had to hand redact those. I finished that yesterday afternoon. So I'm not sure if those have been, I don't know if defense has them yet, but they will have them very soon. But it did take a little bit of time with her last week. And I haven't had a chance to communicate about that with Mr. Martell or Mr. Nasser yet. So I don't know if they're aware of it, but they are coming. I apologize. I couldn't get them done before yesterday.
So you don't have all of the discovery.
I have medical records I have defense copy of 155 pages. So I'm not sure.
At those?
Medical records.
I'm not aware of how any other records would have gotten over. I got records and I redacted them yesterday. I'm not sure.
So you redacted them yesterday. Those medical records you're looking at came before yesterday?
Your Honor, the version I have is unredacted. I'm just not sure if this is the exact same version that the people have.
So we're not sure about what discovery is there and everything. So what I'm going to do is I'm going to put this out 1 week. So that you can look at those. It won't affect the date you're necessarily asking for prelim, but I want to make sure that all discovery is complete on it so that you have an opportunity to have that and your client can look at it or at least talk with them about it.
Of course.
Probable cause conference, I will 1 week to 14th, May 14th, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
Have a good day.
Court calls case, People versus Aaron Brandon.
However, on behalf of Mr. Brandon, who is approaching the podium and will be standing to my right. Mr. Brandon, once you get up here, please state your name for the record.
Brandon.
Thank you. Thank you, Your Honor. The court should be in receipt of my adjournment form. We are requesting for an adjournment at this time.
Where yesterday I discovered another warrant request from Mr. Brady from January, so it's not a bot violation, it's even gonna rain till April, but I did authorize 4 new charges: assault with a dangerous weapon, unlawful driving with a motor vehicle, firearm possession by a felon, and domestic violence against a different victim. So that should be coming in hopefully soon.
Got a couple other cases, so you may have to wait for me in the hallway.
So probable cause conference, I'll adjourn this out. Hopefully, if you authorize it, hopefully we can get it done, get it set, so they'll be together at least. So I'll adjourn this out to May 28th.
Your Honor, I'm not available that week.
Good.
Your Honor, I'm getting married that weekend. If I could just have you.
What?
Or earlier, yeah, I tricked some poor woman into it. So, but I'm not available.
Married that weekend?
Yeah. If I could see the.
So I should ask her if I should set this.
I mean, she will be the real power after this.
And I want you there. No,
Like a week either before or after. Thank you, Judge.
What, you want me to set it for the 21st? I just don't know that we'll catch it in 2 weeks.
Sheriff's office today, and hopefully get that sort two done, so that it'll hopefully be around 2.
Are you available the 21st, or you gotta like stuff you gotta do?
I mean, I'm busy, but for you, Judge, I'll make some time.
Is that how that works? Don't blame me when you don't get something done. All right. May 21st, 2026, 9 a.m.
Judge.
Bond will continue. All right. And again, congratulations,
Judge.
Court calls the case of the people versus Seafer Kent.
Good morning, Your Honor. We're very on behalf of
Ready, Judge. Portia Feaster, Assistant Public Defender on behalf of Mr. Kent, who is approaching the podium. When you arrive, please state your name for the record, sir.
Seaper Kent.
All right.
Thank you, Judge. We did meet with Mr. Kent, and I have had conversations with Ms. Willingbrain. We have began receiving all the discovery. I believe we need an adjournment to receive the rest of it to find out how we're going to proceed, Your Honor.
I did just provide Whiting with a sign of protective order, so just wait for the signature on that. Some additional discovery that did. Wow.
All right. I have signed the protective order.
Judge.
All right. And so how much time would you be looking at?
Not knowing how long it will take, I'd say maybe 3 weeks, just to make sure we have it.
Probable cause conference will then be adjourned to May 28th. You're not getting married, Feaster.
Not again, Judge.
Oh, okay. Okay. That's right. Never mind. May 28th, 2026, 9 a.m. Bond on this matter will continue.
Thank you. We'll come see you again, okay? All right.
Court does call the case. People versus Lawrence Buckner.
And on behalf of the people, Your Honor.
Your Honor, my client just stepped out in the hall. I'm just having.
No.
Thank you. Chris Coverall on behalf of Mr. Buckner.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Buckner, who approaches.
Your name?
Say your name.
Lawrence of the family of Buckner.
Very approach.
You may. An events conference in this case. Starting with the case ending in 0446, there's been an amended complaint filed. Counsel has indicated.
Yeah, we will waive a formal reading stand mute to that, Your Honor.
Then in this matter, I will adjourn it. So I will adjourn both cases out to the 21st, May 21st, 2026, 9 a.m. At this moment, fund will continue. Mr. Buckner? Sir? I've gotten a report, and there are some reports that you were in the vicinity of the victim in this case. All right. Sounds to me like it may have been that you were there. She may have showed up in the area or whatever. I'm not attributing any ill will to that. I'm just going to inform you that you happen to be at stop. You're required to leave. Okay. Be in that area. Am I understood?
I was at work.
Just say yes.
Okay, does it outside of the work? Is it outside of work, Mr. Simpson? Because I honestly, yes,
Because you don't shoot
yes.
yourself in the foot right now.
Just giving you. Say yes.
I said, I understand that, but I'm asking about work. Mr. Simpson, is it also include work?
I have two ways that I can handle this. All right. I am not handling it in a way that is the most harsh. I told counsel that I would give you that admonishment. All right. There's a circumstance where you're legitimately there. Talk to your attorney about that. Okay. And they will be able to advise you what you should do in those circumstances. I am giving you my warning. Right? Am I understood, sir?
I heard exactly what you said. So you told me to ask my counsel if I have any questions in regards to being justified at any location.
Stop there.
That's what he asked me. I'm just showing him I was listening.
Just say you understand.
Yes, yes.
Right. Thank you.
All right.
Okay. All right. What else?
That's it.
Oh, I don't know if I was dismissed yet. Thank you.
You will let him know I could have handled that very differently.
I'll drive it, Judge.
Okay, thank you. All right, that's it. No more Mr. Nice Guy. Sorry for everybody else. Court calls the case. People versus Jason Haydu Banks.
Good morning, Your Honor. Mark Krieger on behalf of Mr. Haydu Banks. May I just have 1 minute with 30 seconds with him?
15.
Okay. Okay. I'm prepared. I hope that,
Okay.
I think it was maybe 20.
Yeah, it's 12. You're good.
Okay.
All right. Your name, sir?
Jason Haydu Banks.
All right. What are we doing?
Your Honor, I have not received any discovery yet, so I'd ask that we have a short adjournment of the probable cause conference so that I can review the discovery and make an informed decision with my client on whether to proceed to preliminary exam.
I gave Mr. Krieger our email address and his certificates, so.
Probable cause conference will be adjourned then to May 21st.
Can I just check my calendar?
Certainly.
That's fine. And what
All right.
time, Your Honor?
I'll set it at 9, but you'll get a
notice, right?
regarding that.
Okay.
All right. Bond will continue. Thank you.
Okay, so
Court calls the cases of the people versus Robert Laster.
Good morning, Judge Hall. On behalf of Mr. Laster in case ending in 1326.
Public Defender Chelsea Virgils with and on behalf of Robert Laster on the other two cases.
And Laster, can you state your name, please?
Robert Laster, Your Honor.
Thank you, sir.
Thank you.
You're looking for an adjournment?
Yes, Judge.
You also, Mr. Diaz?
Yes, Your Honor, just try and keep all the cases together.
All right. I'll adjourn these matters to May 21st, 2026, 9 a.m. Thank you, Judge. Thank you. Court calls the case People versus Angel Martel.
Morning, Your Honor. Alex Warren Green on behalf of Mr. Martel. State your name.
Angel Martel.
Thank you.
Your Honor, I have prepared an order to undergo a competency examination. I would ask the court to order a competency
So
evaluation.
you want a forensic evaluation?
Yes, Your Honor.
Forensic evaluation will be ordered. I'll set a competency hearing date for August 6, 2026, 9 a.m. You prepared that order?
I have, Your Honor.
All right. Bond will continue in this matter. All right. Thank you, sir. Court does call the case of the People versus Nicholas Strunk.
Morning, Your Honor. Sam Bernstein with and on behalf of Mr. Strunk. On Zoom. There he is.
Mr. Strunk, unmute, state your name.
Nicholas Strunk.
Thank you.
Your Honor, we're asking to move forward to exam. Discovery is complete.
Would people have their witnesses available the 19th? Preliminary examination in person, May 19th, 2026, 9 a.m. before Judge, before me. Bond continue. Thank you.
Okay, thank you.
Court calls the case of the People versus, really? Jada Olive.
People.
Your Honor, as to the person that's getting married, the attorney, after that marriage date, he'll be on informal probation.
Yes, absolutely.
She was in the middle.
Sorry, Mr. Allen.
And good morning, Your Honor. Robert Elman on behalf of Ms. Olive in case ending in 131.
Your Honor, Bill Clovis, P 38434 on behalf of the case of 25-16344. I'm sorry, 26F10173FY.
All right. Your name?
Jada.
Thank you. What are we doing?
We're going to be waiving preliminary examination.
He's waiving on both.
Yes, Your Honor, you should have a signed waiver in the file on my.
So all of you, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on all three counts.
Your Honor, we would stand mute and waive any formal reading.
Stand mute.
Defendant having waived formal reading, standing mute to all charges, court will enter not guilty plea as to all counts. Pretrial will be set for
May 18th at 1:30 with Judge Hammoud.
May 18th, 2026, 1:30, Judge Hammoud.
I'm sorry, who was the judge assigned on it?
Hammoud.
Thank you.
Bond will continue.
Thank you, Your Honor.
Always nice to see you, Judge.
Good seeing you, sir. I mean, I can feel it. You'd be right. Court calls the case People versus Raffinian Brooks.
Brandon, Your Honor.
Do I have?
Morning, Your Honor. Rob Chico on behalf of Judge standing in for Mark Shakur regarding Finney and Brooks.
Bless you. Wow. Don't do that again. That scared me.
Brooks?
Well, Raffinian Brooks. They're not here.
Judge, Ms. Krasher was asking for an adjournment. She was just appointed. I don't know if he knows about this hearing. You being the considerate judge you are, and very compassionate. I would ask for a 1 week adjournment.
For you, I would be that way. However, it's Kreischer's case. Bench warrant. 10,000 cash surety.
What was that, 10,000?
Yes, cash surety that will issue immediately. Thank you.
Thank you, Your Honor. My opinion hasn't changed.
Wow. Court calls the case, People versus Antonio Williams.
Morning, Your Honor, Raymond Cook, the people.
Sign this, right? They need to sign this.
I need, no,
No, they don't. Okay.
no, they need to sign the image. That's that, yep.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Williams.
Sir, can you state your name, please?
William.
Thank you.
Now, we've received a competency updated report, and at this time, the report is stating that Mr. Williams is still not competent, but is still restorable, and we stipulate to that finding.
Your Honor, the people would so stipulate as well.
All right, the court will continue the finding that the defendant is incompetent but restorable. I'll set a review hearing in this matter for August 6, 2026, 9 a.m. Bond will continue. Thank you.
Thank you.
Court calls the case of the People versus Jonathan Sims. Who is that? Okay,
Good morning, I'm Robert
thought I'd ask.
Anthony, Jonathan Sims. Judge, we have the discovery. We're asking for a preliminary exam.
Your name, sir? Jonathan Sims. Thank you. You have all discovery?
Yes, Your Honor.
All right. People have their witnesses available the 19th? All right. Preliminary examination, May 19, 2026, 9 a.m. before Judge Garwood.
Co-defendant in custody.
He has a co-defendant in custody. Who's on that?
Yeah.
Okay, before you said that, Ms. Yagi is, what's it? Hickenbottom. It's a co-defendant. Are you also looking to set exam on that one?
Yes.
Okay, then we'll set it when it comes out. All right. Bond will continue on that one.
Thank you.
19th.
I'll give you a call, okay? Well, I should get you.
Court calls the case, People versus Joshua Hillsborough.
However, on behalf of Mr. Hillsberg, who is approaching the podium and standing to my right. Your name for the record?
Joshua Hillsberg.
Thank you.
Today's the date and time set for probable cause conference. We are asking that the matter be set for a preliminary exam.
Both matters?
Yes, Judge, both.
All right. All discoveries complete?
To my knowledge.
And will the people have their witnesses available the 19th? All right. Preliminary examination, May 19th, 2026, 9 a.m. before me.
Thank you, Judge.
Thank you. Bond will continue.
Okay.
Court does call the case, People versus Diamond White.
Morning, Robert G. Thorne, Diamond White. Let me state your name. Diamond White. Judge, we have the discovery. We're looking to set exam dates.
People have their witnesses available the 19th.
Yes, Your Honor.
Preliminary examination, May 19th, 2026, 9 a.m. before Judge Garwood.
Thank you, Your Honor. You're good, okay? Look at this all.
Bond will continue. Thank you. Court does call the case, People versus Aaliyah Benton.
Horrible for everything.
Good morning, Your Honor. James Fatfelski on behalf of Ms. Benton, who is coming out soon. Please state your name for the judge.
Aaliyah Benson.
All right. Your Honor, this is a new file. I'm asking the court to adjourn for discovery.
Probable cause conference will be adjourned to May 21st, 2026, 9 a.m. Bond continued. Thank you. Oh, right.
Just is present. Today, I'm requesting that the defendant sign some documents as it relates to the current care for her children. So I'm just requesting that the defense counsel review those with her and see if she will sign them, or I will ask or it will be, but I hope that would be necessary.
Your Honor, I do have the documents. I don't have a problem discussing those with her. All right. And so I do plan to do that. I did fail to request if I could very briefly address bond. 30 seconds tops.
Go ahead.
Your Honor, she has a $250,000 bond at this point. Her only prior conviction, I believe, is an impaired. She's on bond on a violation of probation with Judge Barr. 5 kids she does need to financially provide for who are under the care of CPS, and there is a family safety plan. I'm just asking that you grant her house arrest so that she can at least work, provide for her children while these cases are pending.
Respond.
So I'm going to check bond at this time. This case involves the shooting in the butt of a 4-year-old, the defendant's 4-year-old by her boyfriend, I believe, who has not been found. The defendant did transport child to the hospital and then proceeded to lie to police about what happened to him, and then tried to leave the hospital without speaking. So I have concerns that he has a flight risk and danger. Given that we don't currently know the whereabouts of who will be her co-defendant, I have additional concerns that she will try to get in touch with him.
Anything else?
GPS tether would help keep track, for Your Honor.
Motion for bond reductions denied. Bond will continue. All right, thank you.
I'll be back very shortly. Go on. Thanks.
Okay. Sorry. Court calls case People versus Kevin Davis.
And James Fifelsky on behalf of Mr. Davis, who is approaching. Name, please.
My name is Kevin Ryan Davis.
Your Honor, just retained on this file, still waiting mostly the video discovery, asking for an adjournment for that to take place.
Probable cause conference will be adjourned May 28th.
Judge, I'm actually out of town that day.
What? What's his name's got a wedding. Everybody's going to be here.
Well, I have no weddings, but family coming into town and
like him?
Family activity. I do. Yeah, my brother, older brother. He teaches me a lot of good things that.
He's not been doing it. Will the 21st work?
Will the first thing in the morning. I know because my other client's in custody. I have a 10 o'clock mediation for the whole day. But if out of custody goes later, that doesn't work.
Okay. At what point on my face did it look like I cared? I'm just picking a date. We'll figure out how to make it work. You want the 21st, but you don't want the 28th.
I can't do the 28th.
Jeez, so Pete. June 4th.
That's great. Thank you. Yes. Very kind of you.
No, it really wasn't. I just got exasperated. June 4th, 2026, 9 a.m. Bond continued.
Thank you, Judge. Have a good day.
You do the same. Hey. Court calls the case. People versus Wesley Brand.
And adults for the people.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Brand. Your Honor, we are requesting in order to get some coverage.
Probable cause conference will be adjourned May 21st, 2026, 9 a.m. All right, thank you. Bond continued. Court calls case People versus Jennifer Baker.
For the people.
Good morning, Judge.
Good morning. You're Miss Baker?
Yes, Jennifer Lynn Baker.
All right, thank you.
Public Defender Jay Bellinger on behalf of Ms. Baker, Your Honor.
All right, what are we doing?
Your Honor, we are potentially going to be setting this. I just need a little time to talk to my client about the repercussions of potentially doing that.
All right. Probable cause conference, May 28th, 2026, 9 a.m. Bond continued. Thank you, Ms. Baker.
Thank you, Your Honor.
Thank you. Have a good day.
Two. Court calls the case of People versus Michael Burge.
And Stephanie Can on behalf of Mr. Burge. Mr. Burge, could you please state your name for the record?
Michael Burge. Thank you. Really?
Yes, Your Honors. I mean, Your Honor, we're just asking for a shalik adjournment of this case, please, for investigation purposes.
May 21st, 2029 a.m. Bond continued. Thank you.
Okay.
Court calls case People versus Shelby Barber.
Stephanie Can on behalf of Mr. Barber. Mr. Barber, could you please state your name for the record?
Shelby Barber.
Your Honor, we are adjourning this. It's my understanding that new cases potential on this. Is that correct?
That's correct. You charged $7,000 and not probably has been 170 from this year for account of old substance infection. I will follow up on how that has just one, two, three.
All right.
So, Your Honor, we're just asking for an adjournment to handle those together if possible.
What I'll do is I will adjourn this to June 4th, 2026, 9 a.m. Bond continued.
Thank you so much, Your Honor.
Thank you. Court calls the case People versus Contrell Cooper.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Cooper, who approaches.
I didn't check the door. Were they? Okay. 3 cases.
That's correct. Go ahead and state your name for the record, okay?
Contrell Cooper. Thank you.
Your Honor, we are just at this time looking to set all of these matters.
For a preliminary examination.
Yes.
All discoveries complete.
Best of my knowledge, Your Honor.
All right. Would people have their witnesses available on these 3 matters on the 19th? Preliminary examination will be set May 19th, 2026, 9 a.m. before me.
Waiting to hear back from that. Before you?
Yes.
Thank you.
Thank you.
Yeah.
Court calls case People versus Manuel Barnhouse.
Here, Your Honor.
Seriously, she was just here. She's like a squirrel. Find her. Where'd she go?
Oh, which one?
Barnhouse.
Oh, thank you.
Mr. Feaster called you a squirrel.
I just,
Go ahead.
they're cute. Your
That's the best she had. All right. Oh, go ahead. That's fine.
Your Honor, we're asking that his case be set for a preliminary exam at this time.
Right. Would people have their witnesses available the 19th? All right. Preliminary examination in this matter will be set May 19th, 2026, 9 a.m. before Judge Garwood.
And Your Honor, that Mr. Bryant's house.
That's
is
in person.
Thank you.
So you'll need to come down to the courthouse, sir.
Yes, sir. I understand.
All right. Thank you.
Thank you, Your Honor.
Have a great day. Thank you.
You too. Court calls the case People versus Trace Hickenbottom.
Good afternoon, or morning. It's morning. Good morning, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Hickenbottom, who's approaching. Could you state your name for the court?
Trace Anthony Hickenbottom.
All right. You're wishing this set for exam.
That's correct, Your Honor.
Discovery is complete.
That's correct.
Set at May 19th, 2026, 9 a.m. I think that's before Judge Garwood. Before Judge Garwood. along with the co-defendant. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case People versus Lamar Butler.
And Assistant Public Defender Jay Bellinger on behalf of, but not with Mr. Butler. Oh, wait, are you there, Mr. Butler? Wow,
That much for
darn.
Lamar Butler.
Unfortunately, Your Honor, my client is listed as homeless. I don't have any phone number for him, any email for him, nor do I have an address for him. So I couldn't make contact at all.
Bench warrant will issue for defendant's failure to appear, bond set in the amount of 10,000, cash surety. Court does call the case People versus Cameron Larry.
Good morning, Your Honor. Public Defender Donovan Lee on behalf of Mr. Larry. Mr. Larry, can you tell the judge your name, please? Cameron Larry.
Thank you.
I would like to please set this matter for preliminary examination. Discovery is complete. Mr. Larry would like me to address his bond as well.
All right. People will have their witnesses available the 19th. Preliminary examination, May 19th, 2026, 9 a.m. before me. As to bond.
You know, with regard to bond, I think Mr. Larry has learned some important lessons over the past 30 days in jail. He understands the extreme importance of complying with this court's orders. He does have stable housing. He can stay at if he's released. Stay with his parents. At 321 Elder Street. My understanding is that they are in the courtroom today. They are aware of the case and of Mr. Larry's struggles with making good decisions regarding his bond. We have no objection to a home confinement tether. He would have a job at Home Depot that he believes he would be able to return to work. In addition, I would just note that Mr. Larry is quite young and this is his first experience with the legal system.
Response.
I think we have no objection at this point to a home confinement tether. There have been no more bond violations in the last 2 years. I know that Julia's have been present at each of the hearings. I believe that they will be violated. Does.
Larry, if I let you out on a home confinement tether, you can follow all of the rules, right? Where are his parents? Where are they? Okay, there you are. You'll keep him straight? Man, I may not want to let you go. I may have to, it might be better I keep you. All right, what I will do, your previous bond had been posted and then you messed up, right?
Yes, Your Honor.
So what I'm going to do, I'm going to reinstate his previous bond. I will order that he be placed on a GPS home confinement tether prior to his release.
Thank you, Your Honor.
And then you'll be set for the 19th before me.
Thank you, sir.
I'm gonna tell you what, you better listen to Mom. I'm looking at her right now. Uh-oh, okay. I can't see you, but I see her. Okay. All right. Thank you. We'll see you in the next. Court calls case People versus Christina Eichert.
Good morning, Your Honor. Marcia Creature on behalf of Ms. Eichert, who I think is appearing via Zoom.
I thought Killerwald was here for you.
Well, it caused
He flew the first one, so you came.
Well, it caused me.
Oh, you're here. Okay, no, I'm just saying.
I was gravely concerned, so I came down here.
Okay.
All right.
I could. Oh, he's in Zoom.
She,
She is in Zoom. I'm sorry.
Your Honor, I would be asking for a order for competency in this case, Your Honor.
All right, got it. I have the order here.
Yes, I prepared that ahead of Ms. Pillawald because, you know,
I don't want. A forensic evaluation is ordered. I'll set a competency hearing August 6th, 2026, 9 a.m. Bond will continue. Thank you.
Your Honor.
Oh, yeah.
Court calls case People versus LaShawn Charles.
You're on reading to the people.
Morning, Your Honor. Assistant Public Defender Alexis Zerps with and on behalf of Ms. Charles, who should be appearing via Zoom. Ms. Charles, can you unmute and state your name for the record?
LaShawn Charles.
Thank you.
You're welcome.
And Your Honor, we just be requesting another, we are very close to reaching some kind of resolution in this matter.
Probable cause conference will be adjourned May 20, 2026, 9 a.m. Bond continued.
Thank you, Your Honor. Ms. Charles will be in touch.
Thank you.
Thank you, ma'am. Court calls case People versus Robert Middleton.
And now we have Your Honor.
And Lord Yaki, Assistant Public Defender with and on behalf of Mr. Middleton. Mr. Middleton, when you get to the podium, could you state your name for the court?
Robert Middleton. Thank you.
Your Honor, there is no offer in this case. We are requesting a preliminary examination date.
All right, and discovery is complete.
To our knowledge, yes, Your Honor.
All right, people have their witnesses available on the 19th. All right, preliminary examination in person will be set May 19th, 2026, 9 a.m. That's before Judge Garwood. All right, bond continued. Thank you.
Thank you, Your Honor.
Court calls the case of the People versus Mario Chavez.
Thank you, Your Honor. Alex Warren, Green on behalf of Mr. Chavez. Your Honor, we did not get any contact information from him at the time of arraignment. We've had no contact with him since.
So you're blaming the arraignment attorneys?
No, absolutely not.
So is this your fault?
I will take full responsibility for not getting in contact with.
You are such a noble guy. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of 10,000 cash surety. That warrant will issue immediately. Court calls the cases of the People versus Michael Moore. All five.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender with and on behalf of Mr. Moore. Mr. Moore, would you his name?
Michael Spencer Moore.
Thank you.
It's my understanding from Mr. Cook that the two cases that he was going to authorize last week have been authorized.
I'm sorry.
The two cases that he said were going to be authorized a couple of weeks ago have been authorized. He's just waiting for a swear to. My client would like a global resolution, so we're asking for an adjournment of a couple of weeks.
And are those felonies?
One of them was a misdemeanor that's going to go to 15.
Got it. Okay. You think you can get all that accomplished by the 28th? If I set it for the 28th and then.
We'll make it happen.
All right. I'll adjourn all of these out then to May 28th, 2026, 9 a.m. All right. Bond will continue. So I'll put that back. Court calls the case People versus Danina Combs.
Assistant Public Defender Chelsea Vergils with and on behalf of Danina Combs, who should be appearing via Zoom. Ms. Combs, please unmute and state your name.
Not here.
Your Honor, to be candid with the court, I have had some difficulty reaching Ms. Combs. I have no explanation for her not.
So when you said you appeared via Zoom, that was a hope and a prayer?
It was optimism, yes. Yeah.
All right. Bench warrants will issue for, in both of those matters, for defendant's failure to appear. Bond is set in the amount of 10,000, cash surety. Those warrants will issue immediately. Court calls the case, People versus Patrick Rowe.
That's also the video.
And Alex Warren Green on behalf of Mr. Rowe.
Patrick James Rowe.
Thank you.
Your Honor, I'm going to ask the court to set both matters for preliminary examination.
All right. Discovery is complete.
Believe so, Your Honor.
People have their witnesses available on the 19th.
Prior to that,
Preliminary examination in these matters will be set May 19th, 2026, 9 a.m. before me. Court calls case People versus Bond continued versus, is it Hetty Diaz?
It is.
Assistant Public Defender Donovan Lebo on behalf
Good
of
morning,
Ms.
Your Honor.
Diaz.
Hello, Miss Diaz. Okay, there
Hello,
you
good
are.
morning. Hello.
Hello, state your name, please.
Yes, my name is Edie Diaz.
All right.
And Your Honor, requesting an adjournment. Ms. Diaz is sending me some additional information I'm going to be investigating.
Probable cause conference will be adjourned May 28th, 2026, 9 a.m. Bond.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Stefan Scott.
Then we have the people, Your Honor.
Good morning, Your Honor. Marcia Creature standing in for the attorney of record, Mr. David I. Goldstein. Hi, how's it going? I'm just standing in for David. We're going to ask for an adjournment. We'll be asking for an adjournment. I believe Mr. Goldstein has provided the court with the green sheet. I believe Mr. Goldstein was just retained on this matter.
He was just retained on it.
I believe so.
Oh, I do have it. Mr. Goldstein.
He was here, but he had on a Zoom.
Yeah, but there were some dates he wasn't available.
June?
The entire month of June. All right. Then I'll adjourn this out to the 21st. May 21st, 2026, 9 a.m. I do have to, because the code's effective date after the earliest date in the offense date range. Excuse me.
That's a big range.
December 19th. It's not available. It's not available until sometime in 2025.
Got it. Who'd you address it with?
I forwarded it to the prosecutor's office. It might have been Miss Tannock. She didn't just stuff on it.
She signed off on what?
On the it's written.
Okay. In order to enter this in our system, the charge is not available in 2019.
Correct. Count 11.
Count 11. So on this case, count 11, which is the malicious use of a telecommunication device involving a domestic relationship, that charge in and of itself was not available in 2019. So we can't enter count 11.
I'm gonna amend that thing under two. I'll read that for this wife thing after I.
Okay. All right. Just so that we get that correct, so we can get it. All right. So I adjourned it out to the 21st. Bond will continue.
Thank you, Your Honor.
That's weird. I've seen that happens. Court calls the case People versus Jaquia Dunlap.
Judge, Torshell Feature, the public defender on behalf of my client. Oh, Mr. Dunlap appears to be here, Judge.
No,
Your
my
name?
Jacques Dunlap. It's Jacques Dunlap.
Okay,
Thank you, Judge. We have reached out, but
that was Mr. Gill's prayer.
yes,
Oh,
it
that's-
worked out for me. We had not had contact with our client this week. Under week, we asked him for an adjournment and asked him that he contact our office so we can establish contact.
I'll adjourn this out to May 28th, 2026, 9 a.m. Bond continue. Mr. Dunlap,
Yes, sir.
you need to call the public defender's office.
Okay.
You got their number?
Yeah, I think so. I talked to him this morning.
Okay. Did they get a good phone number for you and a good email?
The number that I called.
Okay,
that's-
do this. If you're not sure, do this. I want you to call back there. Make sure they have a good phone number and email for you so your attorneys can talk to you.
Okay, I will.
Okay?
Yes, sir.
Thank you.
No problem.
The rest of your things are.
The rest of them when they're ready. Court does call the case. People versus Riley Everett.
Public Defender Davi Lee on behalf of Mr. Everett. And there he is.
Your name?
Riley Everett.
And Your Honor, we're going to be requesting an adjournment in this matter. I did receive some additional discovery yesterday, and we're still discussing some additional discovery as well.
Public cause conference will be adjourned for 2026, 9 a.m. Bond continues.
Thank you, Your Honor.
Here, Your Honor.
No. Court does call the case. Yeah. Yours, her. Court calls case. People versus Diamond Buyers.
Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Ed Ladrukas on behalf of Diamond Buyers.
E45 case.
Diamond Buyers.
We know.
Thank you, Your Honor. There should be a waiver form in all files.
Waiving.
That's correct, Your Honor.
I do. Eat. All right. Spires, is that a correct statement? You're waiving your right to a preliminary examination in these matters?
Yes.
So I just want to make sure we got everything here. They're all felonies, it looks like. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. You understand you'll not have that hearing, you'll proceed to circuit court for further resolution. People also waive their right on these matters?
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on all counts. I see it. Yes, all counts are done.
Your Honor, we would acknowledge receipt of informations. We would stand mute to each charge and ask for a pretrial date. And ask for a pretrial date.
Preliminary examination having been waived, defendant waiving reading of the information, excuse me. Court will enter a not guilty plea as to all charges. Pretrial will be set for
June 29th at 1:30 with Judge Hamud.
June 29th, 2026, 1:30 before Judge Hamud.
I don't know if the court has any control over that date. I did see the co-defendants on one of these cases that the pretrial court that moved on June 1st. Is it possible to keep those together? Or is that too soon to turn around to circuit court?
I don't know. I got enough problems doing my stuff. I think what you'll have to do, I'm gonna set, this is the date well, hold it. What do they have? Do they have an in custody day?
Yes, sir, that would be the date.
I know that. What date? That's the date her other ones are set?
Yes.
I'll do it in this case. If they give you a problem, then let me know. That way I won't answer my phone. Or I'll blame Cook. June 1st, 2026, 1:30 before Judge Hamud.
Thank you, Your Honor.
All right. Bond will continue.
What's this?
Bond continued. Thank you. Shut up, look at them. So I have to be signed job. Information. Court calls the case, People versus Lawrence Fenderson.
Good morning, Your Honor. Assistant Public Defender Alexis Zerps with and on behalf of Mr. Fenderson, who should be appearing on Zoom. I think he's there. Mr. Fenderson, unmute and state your name for the record.
Lawrence Fenderson.
Thank you.
Your Honor, my investigative team have been trying to get some video from Menards, and they've most recently reached out on Monday. Still have not received an update, so we'd just be requesting an adjournment.
Probable cause conference will be adjourned June 4th, 2026, 9 a.m. Fine, continue.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Matthew Frazier.
The people.
Brian Bowling on behalf of Mr. Frazier, Your Honor. You state your name for the record, please.
Matthew first.
Hands on your back. Judge, I'm asking for an adjournment. Needs discovery.
Probable cause conference will be adjourned to May 28th, 2026, 9 a.m.
Thank you, Your Honor.
Fine, continue.
Thank you, sir.
Thanks, man.
Out of there.
Okay, I think. Okay, he's gone. Court calls case, People versus Alan Fry. Or Fife.
Morning, Your Honor.
Good morning.
Assistant Public Defender Lamisa on behalf of Mr. Fife. Mr. Fife, can you please state your full name for the record?
Alan Fife.
All right.
My office is going to be filing a nollie in this case.
No objection, Your Honor.
No objection? All right.
No.
Case is dismissed.
Thank you, Your Honor. Thank you. Thank you all. And I'll hope to never see you.
Not
again,
hope.
Except on TV.
Never see them.
What?
I say, I will never see you again except on TV.
Okay. I was about to get insulted. I don't want to see any of you people ever. I don't know what Lenise did to him. Court calls the case, People versus Filton Gloucester.
Assistant Public Defender Lamisa on behalf of Foster, who is approaching.
Mr. Glasser, can you please state your full name for the record?
Built-in golf.
Your Honor, we are requesting an adjournment in this matter. Mr. Glasser has already scheduled his assessment. And I have given this off to my very capable colleague, Mr. Bowling, after today. But does want to be screened or potentially screened for.
Mess it up, boy.
He is not going. I believe in him. You're in good hands. Don't.
Yeah, don't freak out. You're good. May 28th, 2026, 9 a.m.
Thank you.
All right, bond continue. Thank you, sir. Court calls case, People versus David Grayson.
Stephanie Cannon on behalf of Mr. Grayson.
Your Honor, he just texted me. He told me he had your Zoom information, but I retexted it to him, because he says, I don't have the Zoom information. So I just sent it to him like 30 seconds ago. So he is trying to Zoom in. Yes.
So what do you want me to do? Wait?
Well, I would like for you to maybe move it towards the
Bellinger said no.
could. And I would still ask you to do it though.
What? Of his? Yeah, well, he has more.
He does, Your Honor. A new charge was issued against him on 4/22.
Was he arraigned on it, do you know?
He has not been arraigned as of yet. I let him know about it yesterday.
Okay,
I'll try and get it.
fine, I'll pass it.
Thank you, Your Honor.
Court calls the case, People versus Jamie Gurney.
All this for people.
Are those just interns packed over in the corner?
I believe so, Your Honor.
Oh. Nobody put baby in her. Go ahead. What?
Good morning, Your Honor. Assistant Public Defender Tope, leave on behalf of Ms. Gurney. Ms. Gurney is standing to my right. Ms. Gurney, could you tell the judge your name?
Jamie Gurney.
And Your Honor, we'd like to set this matter for preliminary examination, please, and discovery is complete.
Discovery is complete.
Yes, Your Honor.
Right. And would people have their witnesses available the 19th?
We will try for that date, Your Honor.
All right.
Thank you.
Preliminary examination, May 19th in person, 9 a.m. before Judge Garwood.
Thank you.
All right. Thank you. Court calls the case, People versus James Heron.
And Public Defender Chelsea Ridgefield with and on behalf of Jake. Oops.
James Heron.
And I'm asking to adjourn this one as well for a plea discussion.
Probable cause conference, May 28th, 2026, 9 a.m. Bond continued. All right. Thank you, sir. Thanks a lot.
I'll walk out.
You're doing those waivers. Okay, can you just double check those? Bias. Court calls the case of the People versus Hosea Hill.
Thank you, Your Honor. Alex Warrant on behalf of Mr. Hill. Mr. Hill, can you state the court?
Hosea Raphael Hill, good morning.
Good morning. We're gonna need to deal with this violation.
Your Honor, I reviewed that with my client. At this time, he's going to admit to not only his behavior towards.
Why was he acting that way?
Oh.
You're gonna have to give me an explanation for that. Those folks over there at Community Corrections have to deal with a lot of people coming through, a lot of people that are under stress, and they don't need this garbage. And certainly, and I'll be honest with you, especially Ms. Dozier, does not need this garbage. So before you start talking to me, you better make sure you understand what you're saying to me.
And Honor, before the violation issued, right after the intake terminated because of behavior at the intake, Mr. Hill came to my office.
We're clear. It's not just his behavior. She had to call officers in, try to deal with it, and still tried to do it, and he still didn't do it, and he didn't complete his intake. Go ahead.
My office made me aware of what happened. Sat down with me, wrote an apology letter to Agent Dozier, sent it to her. I extended my apologies on his behalf. And I think to try and put this into context, and he acknowledges there's no excuse for it, but to try and put it into context, Mr. Hill has had medication stolen. He's prescribed medication for a mental health diagnosis. As he scheduled 2 appointments with his psychiatrist to make a plan moving forward. And after sending our apology letter to Agent Dozier, one thing Mr. Hill brought up was if his social worker was present at the time of intake, I think that might help him regulate his emotions, but he's still trying to get back on the medication that he's prescribed. So
we'll just read the letter here.
Well, Your Honor, I can answer any of the court's questions, and I think Mr. Hill can answer any of the court's questions as well at this time.
please, I will answer. Please. Thank you. This is difficult. So what's very difficult, what's going on. But please, I will answer whatever you need to know from me.
Over here. Over here.
I did not expect to go to that meeting and that happen. That's for sure. I'll be open. I'm an open person. And I was just opening up to Miss Dozier about my.
No, you weren't. You were interfering with the intake process. She was just trying to get certain things done.
Can I mention something?
Go ahead.
I was talking to Miss Dozier in a meeting, and there was some confusion. I was confused, and I was explaining to her why. Because the magistrate informed me. And if I go to when I go to community corrections, because he ordered me to go there, and I did everything he told me to do. And when we were in court, when I was in jail, and we were in court, he mentioned about corrections, and I already have past experience with community corrections, so I understand that these things cost money. And excuse me, please, I'm not interrupting anyone, and I don't do that. So if I do, sorry. But once I was ordered to go there, I mentioned the judge in court. I said, Judge, I do not have any money. I just do not have any money, Judge. And he said, that's okay. Community corrections will not turn you away if you do not have any money. So when I went to community corrections and met with her in her office, I mentioned that to her. Because she mentioned that, I asked her, is this going to cost me? And she said, yes. And I said, okay, well, I don't have any money. And she mentioned that, excuse me, I'm trying to talk, sir. I am trying to talk to you.
Here's part of the problem. Your attorney is trying to save you. Oh, you know what? Don't throw your hands down. Bond revoke, adjourn next week. Take him.
Your Honor, we can come back next week on that.
Yes.
I appreciate that.
Oh, you better keep moving. I'll adjourn this out to the 14th.
Appreciate that, Your Honor.
26, 9 a.m. Also, with regard to defendant's bond, without stating everything on the record, I don't think it's necessary. The court is going to reinstate the defendant's previous bond with a scram tether.
May I make a record, Your Honor?
May.
Thank you. And at the bench, we did discuss this case briefly. I did indicate that I understand the court's decision, but for the record, the people were not willing to stipulate to any change in bond. We just understand the defendant was on scram tether and did show that she was working on that tether, and this is an OWI for defense. Thank you, Your Honor.
Yes, that's fine. All right. Ms. Collette, I'm going to give you another shot.
Thank you.
All right. Don't mess it up. Because there's going to, if you drink again while you're on that scram tether, there's going to be nothing Mr. Bellinger can say to me that's going to change my mind. You'll just sit. You understand that?
Yes, sir.
All right.
I do think she was going to admit as well on the record.
Yes, that's going to admit to the violation. Is that correct, ma'am?
Ms. Collette, do you admit to the violation?
Yes, Your Honor. Yes.
All right. How long has she been in?
She's been, I believe this is her 6th day, Your Honor.
Defendant having admitted to the violation, I'll sentence and it's 6 days. Washtenaw County Jail, credit 6 served.
Thank you.
I'll reinstate the defendant's previous bond with the scram tether prior to her release.
Understood. Thank you.
All right. Thank you.
Thank you.
I moved it out to June 4th so they can get the sobriety court stuff.
Thank you.
Thank you. Court calls the case, People versus Devin Gibson.
Is that on behalf of your honor?
Morning, Your Honor. Sam Bernstein with Navi.
Gibson, state your name.
Devin Gibson.
Thank you.
Your Honor, asking the court to please set this for exam. Discovery is complete.
All right. People had their witnesses available on 19th. Preliminary examination, May 19th, 2026, 9 a.m. before me.
Thank you, Your Honor.
All right, thank you. Court calls case, People versus David Grayson.
Mr. Grayson, is hearing by meeting.
Your Honor, wasn't he?
Of course. Your Honor, I don't know.
Yes.
He was there. He had the old Zoom information. I gave him the new Zoom information. He came in. There was a kerfuffle, and then
A what? A kerfuffle? What is that? Find that. I don't know big words.
that's just I don't know. Said it dropped on him, and he was supposed to log back in. Is what he said.
Oh, when was that?
I don't know.
Don't text him now. Would you?
Judge, when I checked, he was in there. I looked, I made sure. Then and now we're here. I'm gonna ask for a 1-week adjournment, Your Honor.
No.
He was here. Okay.
Is there PDs in the next block or no?
Yes, I'm here all over the place.
Quit threatening me. What? There are? That starts at 12:30?
Yes. Early end.
So you got an hour and a half.
I'm gonna say he moved you to 12:30, be there or be in jail.
Should I make him come down here?
So here's the deal on that. Listen, so I'm gonna go with no, because his sister has to be the one that drives him in, and that's where the problem came in. I'm sorry, not his sister, the mother of his child. That's how come he couldn't get here in person today.
Not the same person.
I recognize that.
Okay.
Hopefully they are not the same.
Okay, I don't know. I'm just saying.
So he does not have a ride today. So please, if you're gonna do it.
Shannon,
Yes, Judge.
if I get him in Zoom by 12:30,
Yep,
please have him have a stable connection. I'm doing this only because Ms. Gills said.
Thank you, Chelsea. Thank you.
Court calls the case, People versus Shantia Holloway.
Lord Yaki, Assistant Public Defender with and on behalf of Ms. Holloway, who is approaching. Can you state your name for the court? Holloway.
Thank you.
Your Honor, in terms of the next steps in the case, we are requesting that this be set for preliminary examination, but we do have a bond argument that I would like to make.
Discovery is complete.
To our knowledge, Your Honor, yes.
All right. And people have their witnesses available the 19th? I'm sorry, I didn't. Okay. Preliminary examination, May 19th, 2026, 9 a.m. as to bond.
So, Your Honor, Ms. Holloway is currently on GPS tether and prohibited from returning to the residence. This is obviously an allegation involving her oldest child. Her oldest child does not live at that residence currently. I verified with the DHHS worker that the child who's the complaining witness in this case.
I think I heard this the last time, didn't I?
This is her first PCC, Your Honor.
Is it? Okay. Sounds familiar.
But so the child who's the complaining witness in this case is in Pontiac with her mother, and she understands we are not asking for that.
Whose mother?
Ms. Holloway's mother.
The child is with grandma.
Correct.
All right.
She's not asking, we're not asking for any contact with that child or for her to be able to go to that residence. What we're asking is for her to be able to go back to where she was living before. Her youngest daughter, who's 8 months, Aurelia, is there. And
Months old,
what was that?
months old.
8 months old. And that's the issue. I was finally able to actually have a conversation with the DHHS worker who's investigating this. And I have some documentation here. She supports her having contact with her baby, who's not a witness in the.
Okay. What's the people's issue with? The one child is in Pontiac, or do you not know that?
No, I heard Thomas with her right was the judge was the allegations are that the defendant was extremely intoxicated with the 9-year-old and the 8-month-old present, and then strangles the 9-year-old calls the police, and then it is prosecuted to the point of belligerence. And then the 9-year-old says, she's my arms critical to the point of unconsciousness. So I have concerns with, at minimum, obviously strangulation, accusations, and then the fact that she was drinking so heavily while these 2 children are in her care, especially an 8-month-old who would need her to be sober and competent. So I think at this point, I'm going to object until we move to preliminary exam and see what happens there. And then maybe reconsider having contact with the youngest child.
May I respond, Your Honor? So first of all, Ms. Holloway is testing on a sober link twice a day. There's been no violations. We do have documentation that she sought treatment for alcohol use. She's sober, she's clean, she's getting treatment. We have this letter from her treatment provider. We also have a couple other letters from the director of her baby's daycare in terms of
That's all fine and dandy, but CPS you're saying is saying what?
So the CPS DHHS caseworker said she supports her having contact with the baby. They're not recommending any restriction on that. They are recommending.
Well, there's a difference between having contact with the baby and caring for the baby.
That's exactly true, Your Honor.
I know, I said it. So
my understanding is, and I clarified this with Ms. Holloway, you're not going to be actually living there, staying there. You just want to be able to see her and be able to go back there.
the baby with
Her father.
the baby's father.
Correct. So she just wants to have contact. She's not looking to live there and to actually be the sole caretaker. She's just looking to be able to see her.
Have they arranged any? I mean,
See, plan was proceeding.
Ms. Holloway's been working really closely. I do have her information. She did not give me anything in writing because it's an open investigation.
I will say, for example, that if I received some information from CPS as to this, I think I'd be willing to agree to her having like supervised visits with the child, but I just don't have any information to.
right, that's my understanding, Ms. Yagi, is you wanted her to go back there to be with and care for the child. I don't think, given what I'm hearing, that I would do that. But if there is the notion that and there are those that are saying she should see the child, I also don't fundamentally have a problem with that. And I think that that's probably a good thing. But it's what are the parameters of that, which is part of the problem that I'm having. I don't know what I could fashion necessarily to do that without some input as to what that contact would look like. You know, are they saying, so they're not objecting to the contact, but are they saying she should see the child once or twice a day, or are they saying, what are they saying? I don't know.
So, Ms. Holloway is saying that one, suggestion she had is she has godparents who she's living with now, who, one of whom is here in the courtroom. He is, very supportive, but also very tough. I mean, he is very, wants to make sure that everybody's safe, wants to look out for the baby. Ms. Holloway wants to make sure everything, everybody understands. The,
I don't have I'm none of that, Ms. Yagi, am I having an issue with. I just need somebody to give me a recommendation as to her seeing her 8-month-old and what that looks like.
Safety.
Yeah, I don't. Because otherwise, me trying to do anything, I'm stabbing in the dark, and I'm not going to do that.
Okay. Your Honor, I will develop one and I will send it to the people and seek a stipulation. And if we are able to come up with something that is, could I submit that to the court via writing, in writing for an order?
Submit what to the court?
So for example, if I speak with Ms. Holloway and she suggests, for example, visits at a certain time, while, you know, either the child's father or her godparent is present, something like that with more specific.
If those individuals, whether it be in the form of a safety plan or there are other individuals that have put together a way that this would happen, then I'm not going to have necessarily a problem with it. I don't know that the people would either, based upon what was last said, but I don't know, again, I don't know what that looks like. So I'm not agreeing that I'm going to sign anything without seeing it and seeing where it comes from. It can't come from the defendant of what she would like. It has to be something else that, well, she may like it, but somebody else is going to have to sign off on that. I'm not.
Understood, Your Honor. I will follow up with the DHHS caseworker as well, and maybe if I can get her email, you know, input, I can submit that to the people, and that might carry more weight than.
Right. Here's the other thing, though. The tether she has on is a GPS tether.
It is, Your Honor.
Do you have any indication as to what her VAC was at the time the police arrived?
I'm not sure. There's just a note that he appeared highly intoxicated and was unresponsive to questions.
Okay. So once you figure out what that may look like, the only way I'm signing off is because she's on a GPS right now. The only way I'm signing off is the other ankle gets a scram tether. Because I'm going to make sure there's no drinking.
Understood, Your Honor. I will, and Ms. Holloway wants me to make sure that I say to the court that it's the tether is interfering with her work because she has to charge it and she works in plant, and but the court it sounds like the court is not willing to remove the GPS tether at this time, but I will follow up with you and we'll seek a stipulation from the people and submit something to the court.
And all I'd say is a lot of this interferes with a lot of things that others have to do. And so I get that it's an inconvenience, but I also am aware, at least as I look at this case, that there's an 8-month-old that I'm sure you would like to see. I'm sure she would like to see you, but I'm going to put all the guardrails and safeguards in place that I possibly can before that happens. Plain and simple. Inconvenience or not. Near examination, May 19th, 2026, 9 a.m. I'm going to put that before me. Thank you.
Thank you, Your Honor.
Thank you.
Court calls case, People versus Stephen Huska.
Brian Moley on behalf of Mr. Huska. Excuse me, Your Honor. Your Honor, as you can see, Mr. Huska is not here with me. Her Vinely is in the Strong County Jail. which apparently is bad axe up in the thumb. I
know where here in county is, but thank you.
I didn't know where it was.
Okay.
That's why I told you.
Okay.
And I feel that I'm pretty good at geography. So, well, regardless, Judge, I show that he's in there until September 18th.
Oh, okay. So he's in there.
It's a little while. Yeah.
All right.
So,
So why don't I print it out to the 28th, see if we can get a writ.
sounds great.
Yeah.
Perfect. Thanks, Judge.
Probable cause conference, May 28th, 2026. Bond.
Thank you, Your Honor.
Court calls case People versus Jalen Johnson.
Call this for the people.
And good morning, Your Honor. Assistant Public Defender Alexi Serps on behalf of Mr. Johnson. Your Honor, can we briefly approach on this matter?
Pizza. Yeah, come on. Somewhat of an issue in this case and others, but I'm going to adjourn the probable cause in this to August 6th, 2026, 9 a.m.
Thank you, Your Honor.
Bond will continue. Thank you. Court calls case People versus Neil Joycey.
Morning, Your Honor. Raymond Cook for the people.
Good morning, Your Honor. Assistant Public Defender Alexis Serps on behalf of who may or may not be on Zoom. Your Honor, the only contact information on file for Mr. Joycey was an email address. I did send him the, and I have no other explanation for his non-appearance today. For the record, we'd be requesting an adjournment.
Benchmarks will issue in both of those matters for defendant's failure to appear. Bond will be set in the amount of 10,000 cash surety.
Understood, Your Honor. Thank you.
Yeah. Court does call the case People versus Jules Capoon.
Stephanie Pan on behalf of Mr. Calhoun, who should be appearing by Zoom. Jules, can you say your name for the court?
Jules Calhoun.
Okay, there you go. Thank you. How are you doing?
I'm doing good.
All right. All right. What are we? I have guess I have an April report.
Yes, Your Honor. It's my understanding in that report, my client has been deemed incompetent at this time, but restorable. We would so stipulate to that finding.
Anything from the people?
Would also stipulate to that report, ask the court exception to make a finding of the defendant being incompetent but restorable and set a review date.
All right. The court will find that the defendant is incompetent but restorable. I need order, counsel.
Your Honor, I will get one to the court.
I'll set a review date, a competency review date in this matter for August 6th, 2026, 9 a.m.
Your Honor, may I address bond, but prior to that, may I approach?
Yes.
Discussing.
Which is set for August 6th at 9 a.m. I'm also going to set a status hearing in this matter for June 25th, 2026 at 9 a.m. for other reports to the court on this case. All right.
Your Honor.
Thank you. At this
Well,
point,
I'm going to, you guys now, okay?
bond with its conditions will continue. Ready? Okay, thank you, Jules.
Disconnect, Jules.
Thanks. Zip down.
Court does call the case People versus Javian Lovelace.
And Assistant Public Defender Louise Saab on behalf of Mr. Lovelace. Mr. Lovelace, can you please state your full name for the record?
JV and Lovelace, Your Honor.
Your Honor, we're requesting an adjournment.
Did he just like pick up that piston shirt or is he actually wearing it with pride? Huh? Are you just trying to show off or what are you doing?
I want to win.
Okay, all right.
Fixation, Your Honor. I forgot what I was saying.
I know, me too.
Yes, I was asking for an adjournment.
Yes, you.
The media that was provided to us is incompatible with our system. So I did reach out to Mr. Cook and we're working on
Some type.
compatible.
All right. Probable cause conference, I'll adjourn it out to May 28th, 2020.
Thank you, Your Honor.
Bond continue. Thank you. You go Pistons. Court does call the case, People versus Lilnacia Crosby.
Just to close better job, I believe we have Ms. Crosby. Would Ms. Crosby be logged in by any chance? I believe she's in the Wayne County Jail. And Your Honor, I do believe I know what's going on there. My understanding is Ms. Crosby is actually in a trial today for a charge in Wayne County. So I'd be requesting an adjournment.
Got it. Probable cause conference, county did not. Wait, probable cause conference, I'll adjourn.
28, Your Honor.
Yes.
Thank you.
2020, a bond continues.
Thank you, Your Honor.
Is that it?
Never.
Serious? Wow. If you hadn't made that guy mad, you'd have been out earlier. Anyway, works in recess.
This courtroom session starts off with routine hearings, bond discussions, and scheduling arguments. But as the morning goes on, the judge's patience slowly starts running out. One by one, defendants fail to appear. Attorneys ask for delays, and confusion keeps piling up inside the courtroom. At first, the judge tries to stay calm. He jokes with attorneys, talks about weddings, even laughs during small mistakes. But then the tone suddenly changes during a tense bond warning hearing. A defendant keeps interrupting while the judge explains strict no-contact conditions connected to the alleged victim in the case. The judge gives a direct warning. If you happen to be there, you are required to leave. But instead of simply agreeing, the defendant keeps trying to explain himself. That's when the judge cuts him off repeatedly. Just say yes. Stop there. The courtroom instantly becomes uncomfortable. The judge makes it crystal clear that he's already giving the defendant leniency and could have handled the situation much more harshly. Then comes the line that changes the whole atmosphere. No more Mr. Nice Guy. And suddenly, everyone in the room realizes the judge is done playing around. Later, things get even worse when multiple defendants completely fail to appear for court. Attorneys awkwardly admit they can't contact their own clients, don't know where they are, or simply hoped they would appear on Zoom. The judge responds immediately. Bench warrant will issue immediately. By the end of the hearing, the message is obvious. Courtroom patience only lasts so long. Once the judge believes people are wasting the court's time, the consequences become serious very quickly. So here's the real question. Should judges stay patient with repeated excuses and missed hearings, or get stricter the moment defendants stop following court orders? Like and subscribe for more real courtroom moments.